Welcome everyone to discussion on the Impact Bill 2022. Just a small disclaimer, I have questions for the panelists at the end. I request.
So I think Rashmi is having a bit of problems with her connection. So I will just quickly recap what she has just said. She was welcoming all of us and basically telling everybody how excited she is, but she can't tell us that now. So I'll do that for her. So welcome everyone to Rest the Cases panel discussion on the impact of Personal Data Protection Bill 2022. Before we start, just a small disclaimer for the audience. If you have any questions for the panelists, we will address them at the end. You can put your questions in the comment box and then we will get to them in the end of the discussion. In today's discussion, we have industry experts with whom we will break down the bill and get an in-depth understanding of what impact the bill will have on us and what their options are on the main components of the bill. First, we have Advocate Nipun Saxena, Delhi. He has authored and contributed in various national and national publications of repute and has also worked closely with the Criminal Justice Administration reform. He has worked closely with the Additional Solicitor General of India and worked extensively on various landmark judgments. Our next panelist today is Shashank Vajpayee. He is the Chief Information Officer and Chief Information and Security Officer at Credible. He has more than a decade-long exposure in information security domain across cyber security strategy, GRC, and application security. He is the Chief Information and Security Officer at Credible, which is a leading fintech startup in B2B. Then next we have Advocate Prachi Pratap. She is a body of the Forbes top lawyers. She is advocate practicing in Honorable Supreme Court along with High Court and tribunals like NCLAT, NCDRC, NGT, CAT, etc. She is also a TEDx speaker and she's spreading legal awareness along with standing for gender equity. I would also like to introduce myself. My name is Shreya Sharma. I'm the CEO and founder of Rest the Case, and I will be the moderator today. So before we begin though, we will just show a small video about Rest the Case. So please do watch.
Rest the Case is a legal aggregator platform. A one-stop solution for all services and information. If you have any legal troubles, want a legal service, or need to consult a legal expert, we can help you. Speak with our registered lawyers available in over 200 plus cities. To consult a lawyer, you can sign up or contact us. Click on Find Lawyer, and filter lawyers by specialization, location, or even PIN code. Get contact details of lawyers instantly and contact the lawyers on the website, call, or email. To speak to our team, call us at 928-429-3610 or drop us an email at info@restthecase.com. If you are not looking for a lawyer, you can browse through our knowledge bank to get legal tips, learn about laws in a simplified manner, and stay updated on legal news. That's not all. Check out our extensive library of document templates to access legal drafts. Just select the template you want, fill out your details, and download it to use. In case of any queries, contact us at 928-429-3610 or info@restthecase.
All right, thank you so much for watching. We have added a link to our website in the comments section. You can check out our website post the event. Uh, so it is no secret how much of our data is online these days, be it social networking sites, consuming any kind of content, or even simply when you're just visiting a website. Not just this, but when we don't realize that even when we involuntarily press, accept terms and conditions or accept cookies on a website, our information is out there. With the growing amount of our personal information online, the risk of it being hampered with or stolen or manipulated also increases, which is why the importance of laws that provide provisions for protecting data is also growing day by day. In 2017, the country's Supreme Court declared that privacy was a fundamental right under the Indian Constitution, which led to the apex court asking the government to create a set of data protection rules in line with this data protection bill was created. So to begin our discussion, I would like to pose a question to all the panelists, which will set us up for the discussion ahead. So let's start with the basics. Why do you all think that data is so important in today's day? Anyone can go first. Okay, Ms. Sachi, would you like to go first?
Sure, I'd love to. So, as especially in a post-COVID world, when digitalization happens to what we have noticed is, say you go into a hospital and suddenly you'll get a message from other hospital nearby, or you visit a mall and you will get text on your phone. First, that might be going in some stores. So this all started happening is data being used by businesses for various purposes, especially marketing. Biggest use of data is by businesses, by tech companies, as well as those remain the primary areas. So this shows that data is extremely important for businesses and governments. I mean, the media is not just to connect people. I mean, that's more people and all, but to collect as much data as possible. I mean, everyday activities are tracked. I mean, when I sit in the 30, it immediately shows how long it will take me to reach Supreme Court every single day. Habits are tracked and we are dependent on our phones. And data is the biggest currency at the moment. And as some had said in the telecom subscription data said that there are 1.15 billion users in the second largest, so to say, of mobile applications. So data is, and that is why data privacy bill came into existence, being violated to a big degree. So that is just a little brief cursory look, and discussion will look more into it.
Yeah, absolutely. I completely agree with you. I think that's why today everyone says that data is king. So yeah, Shashank, sir, would you like to add to what ma'am has said?
Yeah. So rightly said, Bachi said that which data is required by business and then by tech companies. As a technocrat on this panel, definitely, I look at data as one of the critical assets, obviously, because as a CISO, it's my prime responsibility to protect critical assets of my organization, and data being one of the crown jewels which I need to protect for. And why is it so important? Be it post COVID, obviously it has enhanced the digitalization curve, the way we kind of consume digital services for has increased. I mean, digital services for knowledge sharing, digital services for as I said, there is tech involved in every line of business. Like, it's ed tech, food tech, agri tech, you just name it. I being part of fintech, so I just say that tech is driving the business. And if when how does that happen basically? Because of the above, because we kind of understand that what data patterns the users consume. For example, in financial services, if we are understanding the financial behavior of the end user, then we can offer them the right products, more products, which they will further consume. So from a tech side, that is what is the importance of data. It is humongous, because we have still it's I would say we have just reached the tip of the iceberg. We can still drill down and start creating multiple data sets within what the data science and data engineers are keep on doing that way. So yeah, that will be my point on data.
All right. Yeah. So basically, the more you dig into it, the more you realize how vast this data can actually be. So yeah, Nipun sir, would you like to add to that as well?
Well, in my understanding of data, I think it's like this. You have a tangible personality, and now you also have a virtual personality. In fact, everything from birth till your death is now in the process of being automated. Once there is a digitization of all those aspects of your life, touching upon say registration of births to which school you are going, right? You have an entire data now being driven, everything being uploaded on various devices, clouds, etc., right? You have the contours of evidentiary value of data being seeing a drastic change. Say for instance, there was something called 30 years back documents used to hold a presumptive value. All of that will be rendered OTOs, because now you can store data going back, archival data going back to ages and ages, right? So now if every aspect of your life is being governed by data, then there's a lot of potential to be harnessed. And therefore, I agree with Shashank when he says that we are just on the tip of the iceberg. There's a lot of data potentially to be harnessed, and therefore you would see a growing tendency to ensure that the data which is of an individual is also protected in that manner and fashion, right? And therefore this particular data bill assumes considerable significance. Although when we dwell deeper into it, I would in a sense express my dissatisfaction with what has come out and what ought to have been, but more for later, I think.
Yeah, some masala for the later part of the discussion. So before we go ahead and discuss the bill in more detail, I think I wanted to address what we could probably call the elephant in the room, is whose responsibility protection of the data is. So in 2022 December, it was reported that around 30 million users, their data was breached and compromised from the Indian Railways database. So we wanted to know from you, Shashank sir, in general, in a scenario where organization's data is breached, what is the organization's responsibility and what is the government's responsibility when data is breached?
No, so Weirdly said. I mean, from data breaches. I mean, because I come from the cyber risk world and the cyber threat world, it is increasing exponentially at an exponential rate, because the threat actors, which are after data, are also very large. I mean, there are state-sponsored attackers which are sponsored by not so friendly nations on our neighboring sides, and all of them. I mean, there are even script kiddies who just want to try some script and try to harness some data out of it. So the protection itself, and creating a secure defenses itself takes a toll on cyber security measures. Obviously, we are kind of now going into an era where we are kind of resilient towards our data breaches. So many times I say that we should be aware that data breach, will happen. It is not that it will never happen. So I mean, we should be kind of resilient on that part. When you talk about accountability, obviously certain guidelines are there which have been enforced. There are now multiple councils within the when I say about data privacy, data security, DSCI has starts running multiple campaigns. We have seen that the nation has come up with the National Critical Infrastructure Protection Center, called as NCIPC, which looks at critical infrastructures like railways, power grids, uranium power corporations, and everything. So obviously there are multiple charters, which are already released, and the guidelines are there. So from a government perspective, I guess they are doing the best they want to do. But again, because the technology scheme of things, also increases so heavily, that it is really not possible to defend against the humongous number of attacks which keep on happening. And this is also enabled by the technology expansion, I would rather say. So the extent in which the communication has grown in past 5, 6, or 7 years, has been very, very, very rapid. We have evolved, from when I say about connectivity itself, we had like we should talk about bits per second and kilobits per second. Now we are talking about terabytes, per second kind of speed, wherein data can be transferred from one location to other location. And when I see about that, obviously, then if there is a breach, the extent to which the breach can happen, or the fallout of the collateral damage can also be huge. So we have seen, you have rightly mentioned about the breach of the data of personal values. Obviously, when we are dealing with personally identifiable information of end customers of like just like you and me, we have to be extra protective, and kind of enforce multiple layers of security, because we want to engage the trespasser as much delay as it can, so that we can obviously identify them. So that's what predominantly we do from a cyber defense angle. Kind of encrypt the data both at transit, both at rest. Even if I'm talking about at rest, it should be a field level encryption on the database. It could be like a kind of encrypting every value. Like for example, if I'm storing credit card holder data, there are very stringent norms of guidelines which are released by PCI DSS, which kind of really enforces end-to-end encryption. There are set guidelines that we should not store the CVV number. It should be just used at the time of transaction. It should never be stored in the systems. Such kind of very stringent technical guidelines should be enforced, or should be kind of released for personally identifiable information, be it say UIDAI information or PAN card information or any other PII data. I guess it is left to the organization's accountability to kind of identify what data they are storing, where they are storing, and if there is any lapse in any, or there is any security breach that happens, the accountability on the organization side is only to report, kind of whatever best can be done in that sense. So yes, it is little murky when you rightly said that what can the government do, what can the organization do, even on the private organizations, what can we do or how to report it. Many times we have seen that many cyber reports or cyber incidents don't get reported as such, because of this reason itself, as to what would be the help which we would receive from the government agencies is still not clear. So I guess that is how it is little complicated. We are still evolving, and it's a global phenomena. It's not that we are lagging behind some sectors as such. Obviously, European Union came very hard on data privacy. Uh, Plus, we should also understand that we, as a nation, also the data literacy, when we talk about cyber literacy or data literacy, is also very far fetched. So, considering that, I mean, yeah, it is an evolving phase, which we are still evolving. That's right.
Right. Actually, I never realized before this that the CVV, when we save our information, CVV doesn't get saved. And now that you said it, I'm like, oh yeah, that doesn't happen. So yeah, that's quite interesting. And so when you say that something is breached, what is usually the first step you have to take as an organization when you realize that your information is breached? What is the first thing you usually do?
So obviously, say for example, if you understand that there is so there are multiple set of actors nowadays. One of the core threat actors which has come in prominence in COVID days is ransomware as attack. They kind of decrypt or encrypt all our data and then ask for ransom money to kind of get release the key to kind of get the data. So predominantly the first thing is to stop the attack, right? So because if it continues to keep on damaging my IT assets, so the first thing which all incident response books of us have is to curtail the attack, limit the damage, what has happened, and kind of do not let that threat actor further flow into other systems, other tenants. For example, as you said, Indian Railways, a certain data center would have got breached, but then there are multiple agencies within Indian Railways. There will be IRCTC who are all connected. Nowadays, everything is so fast connected through APIs that transferring or basically damaging or having foot in one center can cause multiple databases, multiple websites to go down. We have seen this, especially when we see the case of Facebook getting integrated on a Meta platform, Facebook, Instagram, and WhatsApp, and they kind of integrated all of them onto a single platform, and there was a huge outage. It was obviously a technical glitch. They never said it was a cyber attack. No, but that is the fallout, right? Once these three were different entities, and there was no sharing of the data between them, then it was running smooth. We could have consumed WhatsApp, Instagram, and Facebook quite differently. But then obviously, Meta comes in, Zuckerberg comes in saying that yes, it's a good data potential. Obviously, that's why he has invested in these companies and bought out these companies. So he wants to have that data as I said, it's just a tip of iceberg. He wants to do multiple things on the Meta platform, and so for that integration is required. And the moment it's integrated, any breach or any malware can flow from one system to other system. So obviously it becomes very challenging from a security defense perspective. So first step is to obviously contain. The second thought comes is to obviously report. So what we'll report is we have to assess first, right? But what is the damage? What kind of data got corrupted or stolen? What kind of systems are damaged? By how soon can we be back up and running? This all things go into the incident response as a template, and this is what asked by certain also under Ministry of IT. So kind of, and it is now mandate has come in that we have to report it within 6 hours of a breach. So it is, we have to be on our toes to understand what's wrong, what has gone wrong, report it. So this is the second part is on the compliance reporting. The first piece is obviously to contain, second is compliance reporting, and then third is obviously to bring back ourselves, the data backups, restore the systems to its full potential, start giving the services to the end customers. And also we understand that media in this modern age plays a major role, right? So we have to be also in the forefront so that there is no wrong information flowing out in the system, so that it's not that it is causing a panic on our end customers. They are well informed that yes, there has been a breach. And I mean, that's what I said, that data breach should not be a taboo. It is like, because there are so many threat actors that we are bound to get breached. Like all of us, we use a lot of payment gateways nowadays. You can use Paytm, PhonePe, Google Pay. We are always everywhere. So it should be a known fact that we can get cyber frauded on those fronts. As a cyber guy, I'm telling this, that it is never possible that you will never get a OTP fraud, or you will not be exposed to it. You will definitely get it, because you are consuming services. You are susceptible to such kind of attacks. So you should be knowing that. And once you're aware that yes, this kind of thing can happen to me, then it makes us more resilient. So yeah, that is how I keep it.
Right. Sorry, just before I stop asking you questions and leave some questions for the audience as well, I just want to know, do we have do companies have like a list of things that they are allowed to save, and data that they're allowed to save, and things that they are not allowed to save? Do they get that from the government, or is that something that, so how does that work?
No, so from, as I said, different guidelines are in place. Now, for example, in typical financial services, if I see, we have seen that there are stringent norms coming in from Reserve Bank of India, wherein data purging is now really a thing of factor. I mean, this was not there in past, say, 3 or 4 years. It has just evolved those circulars. They are now asking, for example, the credit reports, right? Because we kind of keep on, consuming, we keep on spending, keep on earning, keep on incrementing. So the credit profile, what we have, the CIBIL score or credit score, that also keeps on changing. It might go down, it might go up, right? So what used to happen is certain reports used to be stored in the system for long duration. So, for example, Shashank Bajpayee's credit score, about 1,000 would be somewhere around 700, which is like a good score. But then I kind of default on some credit card payments. My credit rating goes down. So it is dynamic in nature. But certain systems, because they used to rely on old data, they used to kind of give it that. So I'm typically talking about credit things now, and it is as one of the things which strike my mind, where data purging is now mandated by RBI. You have to purge 6-month old data, and that is an ask by not just RBI, it's also by all these agencies who give us these ratings. So I mean, this is one of the things. But yes, as I say that it should be at the what you can say, at an organization level itself, data classification and categorization, so as to understand what amount of criticality of data we are handling. Right? For example, if you've ever been to a jewelry or gem shop, whenever they are assembling very tiny precious jewels, they do it within a box. They don't even touch that, and they enter into the box with their gloves on, and then they kind of do whatever they want to make changes onto those precious gems. Similarly, we have to understand that what critical infrastructure, what critical sensitive personal information we are handling, and then put robust security controls around them. So it is obviously left to the technology teams to do this kind of a job. Obviously, there are guidelines. It says that if there is a PII SPDA Act also. Obviously, my fellow panelists would tell more about the legal stuff, because obviously they are the experts on that front. But from where I see, obviously there are a lot of acts. But yes, there are from a technology space or from a organization space, I guess it is more due diligence is required, internally to be done, so that we are, safeguards against any breaches, and also not just breaches, also we live to our accountability. As you actually said in the first thing, so we are accountable if we are giving certain X amount of services to the entitled users. We are accountable to them also. Uh, Obviously, we are not in a litigative country like US, that some end user will start come and obviously in this case of railways breach also, I don't think so that someone would have filed a case against railways. I don't think so that would have ever happened, because it is we are not in a litigative nation like US. But that doesn't mean that we are lax on those fronts. As a technocrat, we obviously have to. What I see is that we are trying to protect data from breaches, definitely, and also against cyber attacks. And obviously, the data analytics and engineering and everything can happen. But as I said, just as how the jewelry shops, they kind of play around the gems in a very closed container. Similarly, these data analytics who are to create new products out of the data should be given very limited restrictive access. The data should be masked, like whatever is the phone numbers and all, which are like personally identifiable, they should be masked, because that is really not required. They want to understand what demographic, they want to kind of what the demographic of individuals are purchasing the products, what is the age group. So they really don't require your date of birth, right? They want the age group. So we can categorize that in age groups. We can mask them and give it to these analytics teams so that they understand better, rather than giving them date of births, and ultimately it gets breached by some third party vendors, or because there are so many actors in play now, because the data flow has become so seamless over APIs. Within minutes, we can exchange terabytes of data, and as I said, it is really humongous. So that is where we have to be very sensitive as to what data is flowing out of my system, who is taking what, and in which state it is going to the other entity. Yeah. So I guess
Right.
that's how Samita.
Yeah. Thank you so much. So in a recent judgment, it was said that the judgment, I'll quote what the judgment said. So it said that this is why laws and rule making for the internet have to be around the basic foundational principles and expectations of our citizens of openness, safety, trust, and accountability. So the government said this on the purpose and need of a bill of this kind. So, what is your opinion, Nipun sir, on the need for the bill in India?
Well, the need for the bill is long past, has been in existence for longer than I could imagine. The need existed in 2000, but with tech and law, what is a general accepted notion is that law is at least 10 steps behind tech. By the time technology comes into picture, the law tries desperate to chase it. So while tech is running a 200-meter sprint, law is running a marathon, right? And by the time law tries to catch up, there's of course a new technology, because with every new technology, the predecessor becomes obsolete, right? Now let's put this in context. In the year 2000, the Information Technology Act, as we all understand, came into being. Until 2008, which is 8 years hence, there was no need felt to put one of the terms that you used, accountability, onto the companies, to entities, etc. Right? So it was only in 2008 that Section 43A was incorporated. Right? And it said that all these corporate entities are supposed to take reasonable security measures. Please understand, one should appreciate the expression reasonable security measures, right? Because security measures are supposed to be foolproof. There can't be a deviation from security measures, because at stake here is the very data, the very virtual identity of an individual. Now, if you qualify that word by reasonable, you are essentially throwing it open to a legal jargon. Let me elaborate on it. Say, for instance, you keep your deposit in a bank locker, right? And theft in the bank locker, and because of which the bank loses its own deposit as well as the customer's deposit. Consistently, the law was that unless this bank is a nationalized bank, which is discharging a sovereign function, the bank will be liable for whatever goods damaged. But if it's a sovereign function which is being discharged by a nationalized bank, or let's say Reserve Bank, then the bank will not be liable. Why? Because it took reasonable measures. Which is to say, a customer may have lost their goods, but the bank also lost the goods. Therefore, all loss is good loss, and the bank need not be made liable. The same standard is now made applicable to the private entities, courtesy Section 43A of the Information Technology Act. Now, one takes a step further. Now, this was 2008. In 2011, the IT SPD rules come into picture. Now, one would assume that IT SPD rules would say what are those reasonable measures and what is the penalty. That's a basic thing. Now, let's say you are supposed to do X. If you fail to do X, what is the penalty? Regrettably, there is no penalty mentioned in the rules. So, Act defines that there's an obligation, but if you fail to discharge that obligation, what is the penalty? The penalty is silent. That shows the commitment to authenticity, transparency, and so on and so forth. Now let's take a converse, because Shreya, you were discussing about data breaches. From an organizational perspective, Shashank has given you an excellent oversight on what it is. Now let me tell you what the legal impediments are. Suppose there is a data which is being breached by a corporate entity, right? Breach of data was never a violation, so to say, within the precincts of either Information Technology Act or the new bill. The bill doesn't even define what a sensitive personal data is. For that, again, you have to go back to the Information Technology Act. Information Technology Act under Section 43A subclause 3 defines sensitive personal data as may be defined by the government. So now the government gets the right to choose what is sensitive personal data and what is not. So then you go back to the rules. Now the rules give you an excellent idea of what all categories of personal data would qualify as sensitive personal data. Rule says your passwords, your financial information, your medical history, your physiological state of mind, your physiology, your psychological state of mind, etc., or any records, including your biometric information. Barring biometric information, if there is a breach of any of these other data, there is no penalty prescribed. Section 43A says in so many words, they may be compensated. Now, imagine a situation like you said, that 30 million data of railway users was breached. What happens then? Who is to be held accountable? And to what extent? Because then comes section 18 of the draft protection bill, which carves out a neat exception for state instrumentalities. So all that the railway has to come to the court and says, sorry, we are exempted under section 18 and therefore no liability. Now, there are, in fact, the exceptions or the exemptions to liability far outweigh the liability itself, which is one of the biggest problems. So in my understanding and estimate of sensitive personal data, I think it's a very dishonest attempt on specifically when billions of individuals own identifiers, personal identifiers are at stake. I think Aadhaar Act in that sense, although I don't agree with a lot of what Aadhaar Act has done, but to a considerable extent, Aadhaar Act at least makes an endeavor to impose a penalty. Say section 37 very clearly says that if you breach biometric information data, section 29 says that there's a restriction, no other entity can use it for any other purpose. Section 35 and 37 jump in and say that if you do decide to breach, then there is a penalty of 3 years imprisonment to the person. In fact, there is another provision in the Aadhaar Act which fines companies to the tune of 1 crore rupees or 10 lakh rupees per day for violation. But again, there's another problem with it, which is to say section 57, which says that earlier section 57 of the Aadhaar Act gave power to all private bodies to use Aadhaar data. You would recollect that time when telecom operators were calling on your cell phone numbers and asking you to link your data with your Aadhaar number, right? They said, oh, we need this for the purposes of authentication to remove deduplication, so on and so forth. The Supreme Court in K.S. Puttaswamy judgment came down heavily on these private players and say, sorry, what business do you have collecting Aadhaar data, which is in fact biometric information of an individual? How can you do it? And then the Supreme Court read down section 57. The Parliament went a step further and 2019 omitted the provision only. So now there's no provision which exists. But one question that begs consideration is this: what happened to the data which was already collected? Was there a sunset clause anywhere, either in the judgment in Puttaswamy or in terms of the Parliament's clause being incorporated saying that within X amount of time you must delete all data? So the data which has already been compromised or jeopardized, because as I understand, and I'm sure Shashank would also agree with me, that an individual can't grow new pair of biometrics. This is what this is. If it is compromised, it is gone. And the loss which is caused is irreparable. You can't graft new iris or put, as is shown in movies, you can't just do it at the drop of a hat. So the loss of information is irreparable. And therefore, what is being sought to be done versus the damage that has been caused, the hiatus is huge. Which again makes me wonder whether this bill seeks to even achieve any of the 4 objects that you just mentioned, Shreya. Pardon me for being slightly there on a pessimistic note, but the sheer wordings of the statute don't do justice to the objective that it seeks to achieve. Thanks.
Right. So, but before I ask you any question, I want to say that the lines you start with, when you generally start talking and you start with the lines, those lines should be on t-shirts. because there's always some line you say that is just like, oh yeah, that's such a smart line. Like even the one you said about the marathon now, I think those are good lines. You should think about that.
I'll be sure to
So
do it.
yeah, we can see something together. Uh, so I want to ask you then that so when Shashank was talking and he was he was saying that usually what the step is when a breach happens. He was saying that you need to stop the breach and then you need to file that breach. So when you do that, so then what legal steps are you supposed to take? If you're saying that there's really nothing that can be done, so then
Well, there are two components, Shreya. One is the compliance component. Shashank
right,
is adverting to the compliance component. That see, these are expected standards. A company must have these on their checkboxes.
right,
But in case something happens, something were to go downward, Shashank himself answered the question saying, "Who will file the case?"
right,
Now, assuming somebody does make that endeavor to file, say, a suit in a representational capacity, I think the only remedy for somebody is to file a representative suit seeking damages for, their breach of privacy. But unfortunately, unlike Aadhaar Act, let's understand what's the broader conspectus. Sensitive personal data, as is defined under the IT Act, is wider than what is defined under the Aadhaar Act. Aadhaar Act only takes one part of it, which is biometric information, and says that if you do X, then so many penalties will follow, which I already told you, 3 years imprisonment and 1 crore rupees fine, and so on and so forth. There is absolutely nothing if any other information is taken away. Theft, as is understood, is of a movable property. Traditional IPC offenses, say section 378, 379, they don't apply. Data theft, in that sense, is only, let's say, if there's an alteration with the network. That also you have to prove by leading investigation, etc. So I'm sure the law is trying its level best to catch up. But the existing framework of the law is hopelessly inadequate to deal with situations such as this. In a case of a massive data breach, you will again have to go back. Say crypto wallets being locked down, a back channel being created to take away the investors' money, FTX, so many, so on and so forth. So many such examples are there. It would be very difficult for the law enforcement agencies in India to tackle these disputes.
right.
To
So
bring,
they're trying, but they haven't reached there yet, is what
yes,
you
because
think.
there's no provision for them to book somebody under. And so what is happening is you are trying to fit, let's say, a rather slim person in an oversized coat, which existed way back in 1860.
Right,
You are booking a person for offenses committed in 21st century under the provisions that existed in 1860. It's very difficult. It's
right. Okay, thank you so much. My next question is to Prachi ma'am then. So the Personal Data Protection Bill in 2019 was introduced on December 11th, 2019. This version of the bill was then withdrawn as multiple changes were proposed. According to you, does the new bill introduced in 2022 have those necessary changes from the previous versions, and will they actually help bring us change? I mean, I know you already kind of touched upon that, but your opinion on whether the changes actually make sense or not.
Right. Which kind of sums it up all in one is that the initial bill had 9 points, and this current one has 30 clauses. So that shows that automatically, right? And it means that a big crucial fragment of subsequent rulemaking has. So a lot has been delegated, a lot has been, curtailed in ways that will not be defined, outlined and defined, but in hidden ways. When we read it thoroughly or when we analyze it in bits, we realize that king is there. The 90 thing has been made very concise. It has borrowed heavily from the data protection in EU, which will come to later, a bit of the 2022 bill at the moment. So, of course, it covers the data. It talks about digital data, not manual data. Now, why? Of course, because it's digital data privacy, so we think it should not cover manual, but there is data that goes, that is already with the government, other platforms, and or with other people, which is not covered of this bill, and which will in turn be used, but they will not be this bill for us. So then there is public interest. Degree of public interest can be subject to misinterpretation, because see, a very broad term. As I said, if something has been reduced from 90 to 30, that means that has happened over the years, that they have thought about, that they have received information about, easily hidden under the bill in the subtext, but it will be there, when the cases come or when a situation there. So if say somebody says that it is the definition and degree of public interest interpretation, because what might be public interest, say, in certain social dynamics, might not be the same public interest in a state with a different interest. In India, that internet has been turned off more than most other democracies, is where issues like public interest come into play. The next, as may be prescribed, which has been used around 18 to 20 type number, and this indirectly gives excess power to the center, which has been there in data privacy bill, that is it giving excess power to the center, and at this point, in a democracy like India and over, which has often got terror threats and all, instances, it is important to give that excess power to the central government. The peculiar feature of this bill is that it sets duties imposed in the clause 16. Now, the data principle, it will be a person, me, an individual entity who is using and accessing the data. So these duties, I would say, because they are very ambiguous. In some senses, I'll just pull up the bill and read one point where it talks about. So it's a principle shall comply with the provisions of all applicable laws while exceed the provisions of this act. So he's supposed to comply with the provisions of all applicable. How would the data principle know what are all the applicable laws? I mean, most of the laws that we are giving our consent to, that is our duty to follow. So these are the point. It becomes very ambiguous. There's a big change. So not complied for, there will be somewhat of a penalty for, say, I don't know the exact amount. So there are these shifts that we are noting in current data protection bill. So the other is right to be forgotten. So this is right to erasure. Now, right to erasure was introduced in the GDPR, and again, this right to erasure is not complete. It is right to erasure under this bill. It is again very vague. So we have shifts which might be good, but shifts that are just a background outside, and which may or may not be righteously imposed on us. To look at it is not not just individuals, but of course, the bigger picture of it, where the legal anthropology is in play whenever a new bill is drafted. The one good thing that has happened is that the draft permits cross-border interaction certain notified countries and territories. So this was a big which I think Mr. Vajpayee might agree, because he knows more about it. Knowledge is there was a set of a small lobby group of which had requested our central government to permit cross-border transfer, and this should be allowed for free movement of data from and political interference, and minimally regulated, but the government did not. However, they allowed a certain degree of cross-border interaction of data, so that there is an easy movement. However, the bill proposed 30 million fine if in an event if a firm fails to provide reasonable to prevent from personal data breach. Now, this will be imposed on the firm. So I don't know how things like hacking and etc. will work over there, because then we will have to analyze it compared to international laws of different countries in place. So that will be over there. Anyway, so and if the firm fails to comply with said, and there's a failure for disclosure of personal data, are going to be fines imposed in this cross-border data transfer. There was another thing that was interesting, was that the clause 19 of the Bill of India. According to the provisions of the bill, the board which will have the powers equal court would entirely be constructed by the central government. Now, this bill to exempt any state body which it deems fit to be exempted from it. Again, a lot of power has been transferred to the central government as far as individual is concerned. Now, this becomes very threat privacy. Maybe when we discuss further, comparing it to laws in place, and I would elaborate more on why I particularly feel it this transfer of power government might be harmful for individual data. However, we should at in a country as populated and as big as India, which has faced years and terror attacks over the years, the government has to be extremely cautious about it can exercise on data protection. Also, because we're not just talking about your social media data, we are talking about data protection when it comes to money, which is one of the chief source, not only in India, but money laundering is one of the chief sources of and human trafficking and drugs. So the government finds in for it to be able to control data. If they put too much, they may step back and they forego the control, able to control all these illicit activities that happen. So definitely currently a double-edged sword, and as we have seen many bills evolve over the years, as and when some common law country, as and when a case comes, an evolution happens. A new amendment might happen. So as when this turn it comes into play, we will see more about how it evolves with the current social legal.
Right. So if I'm not mistaken, when we were trying to do the research for the panel discussion, we kind of saw that there are some principles that the government has laid down in the new bill, and said that these things should kind of be followed. Like, for example, they said transparency. I will just read something from that. So it says that the individual must be informed how their data is collected and used and shared and stuff like that. But when the government is handling all this and is deciding, what should be shared, what shouldn't be shared. And like you said, our population is so much. So won't it be exceptionally difficult to control all this and to control what kind of data is being seen, what kind of data is not being seen, that kind of thing?
See, that is true. When they say about control, and as we mentioned, even if there needs to be a transparency. So if say you request under whatever your I request, then we will have access. There might be transparency, but transparency places it as it is written, that it as it is prescribed, or it may be prescribed. So every clause in this bill, right? Secondly, as far as population is, say data privacy of vaccine records in USA. So the COVID vaccine is not a digital certificate; it's a card where it's written, handwritten, not your vaccine and the name of the vaccine and the date of the batch number of the vaccine. Done because the government cannot, as per their data privacy laws, they are not allowed to keep. In India, we have digital accessibility to our find very convenient. However, there's a you can say there is, how does the US government has access to how many people have been inoculated by COVID vaccine, the number of sales of the vaccines that have happened, so that data is there. Also under date of birth, so they can do. But the biggest catch is, most of the time what people do is, husband has also done, is he took a photo of his COVID vaccine card because he was afraid. So what he did was he just sent it to me, took a photo, sent me on WhatsApp. So that was no longer, he has shared it on WhatsApp. That image is no longer covered under data privacy, and that is what a lot of. So you see, all this tomorrow, if an American data of my vaccine, you have the record for my vaccine data, by you shared it on your card or on your phone with somebody, or the people who have posted on their social media. So of course, it's you no longer have a right to it. So these are the cases that are going. These nuances will happen, and this is where the government has to have the stronger and the bigger things that we are saying are hidden in the agendas bill, which later, when a certain case court and will be finally proposed in front of the Supreme Court, and then thread out the bill and read the act and then figure out that this is hidden, some figure out a way around it, or something new has to come. So that is what does not come into play. Transparency is only there for the government. It is never there for the public. It shouldn't be, because if there is too much transparency for the public, then we know that a lot of wrong also.
Right. All right. Thank you. So the government and state agencies have several exemptions from the proposed law in the interest of national security. So the decision was justified by saying that national and public interest is at times greater than the interest of an individual. So on one side, the bill discusses the importance of protecting individual data, and on the other hand, public interest is put at a higher pedestal. Do you think that it contradicts the main aim of the bill?
Yes, I personally feel. Who would like to take it? Yeah, Nipun might, or Mr. Bajpayee. Yeah.
No, it's okay. It's okay. I'll sorry, am I audible?
Yeah.
All right, very well. See, it's very easy to draw parallels with the Telegraph Act because it has exactly the same restrictive facets on the ground of sovereignty and integrity, friendly relations, public law, order, decency, morality, and the entire realm of restrictions in order to prevent from commission of any crimes or on the basis of contempt or defamation. These are well accepted restrictive measures which are there. But the Supreme Court in PUCL versus Union of India. It's quite the celebrated judgment on the realm of right to privacy. Said that you may even get the option, the state can exercise its sovereign power to carry out, say, wiretapping or phone tapping of an individual who is suspected of committing an offense. But there were close to 20 to 30 such restrictive measures that the Supreme Court laid down, saying that it cannot happen without, say, the subjective satisfaction of an officer not below the rank of an IG. Thereafter, it will only be done for a limited period of time. You will have to submit a report for a periodic review of the information or the data which is being collected, etc., etc. Right, and you have to submit it before a committee. If the committee comes to the opinion that nothing incriminating has come out from the individual, then at the very highest, which is preservation of law and order, or you are suspecting somebody of committing terrorism related offenses, but if you don't find anything on that person, then you must completely abandon the exercise forthwith. Right, so a more invasive statute, which is the Telegraph Act, right, also has so many protections embedded, and when they were not embedded, the Supreme Court through directions laid it down until the Parliament could come up with law to fill the legislative lacuna, as if it were. Right, now the problem with the present bill is, while it gives you all those restrictive measures, public order, decency, morality, yada yada, it doesn't talk about the qualifications which are necessary. It may have, the legislators could have sort of shared wisdom or drawn some wisdom from the judgment of the Honorable Supreme Court in PUCL, or thereafter taken note from, let's say, Telegraph Act. In fact, what is the greatest problem with this particular bill is that it is self-contradictory. This bill also contradicts various other provisions of different statutes. Right, say, for instance, let me give you an example. Under the Prisons Act, every individual who is now a prisoner has to give details of their height, any facial scar, or any mark, so as to identify them, their body particulars, etc., who is their next of kin. In the event that this person were to run away, the law and order could catch hold of that person. Now, this also qualifies as sensitive personal data. You are giving description of your entire body, etc., etc. Now, let's say a prison, and there's a data breach in a prison facility. What happens? Certainly, the Prisons Act is silent on it. Does that cease to be a data, or does that cease to be breach? If so, who is liable? Because conveniently, the prison department will invoke Section 18, come to the court and say, sorry, we are not liable, because we were doing so in in the interest of, say, in compelling public interest, as if it were. And therefore, even if it's a breach, we are sorry, but nothing. Of course, Rudul Shah, D.K. Basu, there are so many judgments of the Supreme Court where it says that merely because a person is a prisoner does not mean that he or she ceases to be a human, and therefore human rights, fundamental rights, should apply with far greater force, if not less, to those who are inmates. You take another example, the National Food Security Act. And the NFS Act makes it specific that the amount of ration which is being distributed to a person will be done in a private capacity, in the sense that you will not glorify the name of the individual, falane ko ration diya tha, tikane, because that denigrates their dignity.
Right.
But now, let's say you have an exclusion specifically carved out if there is a data breach, because they say that if for the purpose of any archival or statistical purpose, if the data gets lost or if there is a breach, then you won't be held liable.
Right.
So tomorrow, your entire public distribution system failures, or failures of midday meal scheme where Aadhaar numbers have gone out in the open, any governmental agency can conveniently take up this defense, which again makes me wonder whether the exceptions far outweigh the so-called object that the present draft bill wanted to achieve. In fact, if you look at, there are so many, there are so many legislations that come to my mind. The parliament, while enacting this particular legislation, ought to have taken other legislations into account, so as to make a law which is harmonious with other legislations.
That is true.
This particular bill, with utmost respect to the draft persons, has not done complete justice. And I would be surprised if if the virus of this particular act is challenged, it won't survive in a constitutional court. You can be rest assured. With the amount of, as the law currently stands, if the bill is accepted, tabled before the parliament, and I think it would be open to myriad number of challenges from different sectors.
Right. I think somebody else was making a point before. I think was it Prachina?
Well, Nipun has successfully covered most of the things that that I absolutely completely agree with him on those, because that we were noticing when we did the 2019 bill was it held that right to private. It was necessary to protect the personal data. Here it completely breaches it and about the processing of digital personal data in a manner that recognizes both the right of individuals and need of personal data for lawful purposes. So when it comes to need of personal data for, I don't know how many provisions it is going to go hand in gloves with and fit with. As Nipun has successfully covered most of it, I personally totally agree with what he has said. Of course, it is important for a government to say that and to follow that the topmost, but somehow, somewhere, they have superseded personal data and has covered it all under the lawful needs. So just you can say just a facade, which is of course needed, because when it comes to national or anybody else will say no, this is okay, it's okay, no, my security is more important than national security. No, it isn't. So we all are bound to agree with it. Our responsibility towards the nation. However, we must admit the security and right to privacy is going to be sacrificed in light of this new.
Okay. And Shashank, sir, would you like to add something to this as well?
From a technocrat's view, I can just add. I mean, legal experts have already spoken their view, but see, from where I see, obviously much has been said on the legal aspects, and how what Prachi ma'am was also explaining, that data sharing of private information is becoming such a nuisance, because we have so many tech platforms in which you can literally share anything, right? For example, over a Facebook chat, Shai could be asking my Aadhaar number, I could be sharing that, right? So it is as many platforms are there to interact socially. We have our own digital version of ourselves existing on the technology platforms, be it anyway, and there are many of them, right? So so I guess my 2 cents on the front of data privacy, I guess it should be more educated, right? And it should be more driven by force, by individuals themselves, saying that what am I sharing, where am I sharing, and so on and so forth. It is because as I see it, in the Indian geographic sense, we are amazing users of technology, and with the amazing, I see that when I talk about, say, UPI transactions, I mean, volumes are there. I mean, I did not speak about the number of transactions, the billions of rupees have been done. So we are really brilliant in using tech. That was even Baji was saying that it was very easy to get the COVID certificate, vaccine certificate, and show it to anyone on mobile. So I mean, so we are amazing users of tech, and that is heads down, and we have adopted tech. We engineers, technocrats are enabling endpoints, but at the same time, it is as rightly said, that the digital literacy amongst the users of these tech has to also exponentially grow, because then they are made sure that where they are sharing, what kind of data they are sharing. For example, in case of UIDI itself, I was just talking to someone, a friend of mine, and I said that, why are you sharing your unmasked Aadhaar? There are two versions of your Aadhaar. If you go to M Aadhaar on your mobile app itself, you can download your the masked Aadhaar itself, and that is what is required to show your identity, because it is in fact your PII data, but it is again masked. So your Aadhaar number does not gets revealed. So that is you are completely unknown to this front. They said, okay, I did not knew that this ever existed. But yes, so I guess that is also one of the things that the awareness and education about privacy is something which should be enforced. Because I've seen a lot of congressional hearings of Sundar Pichai, Mark Zuckerberg. You can see them, where congressmen are asking that if I take this phone and I walk from here to there, will Google know where I'm walking or not? I mean, and he's
Yeah.
speechless, right? Right? So because definitely they know it, right? But I'm not specifically as a tech giants. These are big tech giants. They have been penalized heftily by GDPR. In fact, I know that even Google has been fined by Indian, some guidelines have been issued against them. So I mean, I guess that they're heftily fined, but it is really nothing in case of what they are collecting in terms of data which they are collecting, and it is because of how we use it. So as I said, if we are amazing users of tech, we should also be amazing users of our data privacy. Then obviously we can counter the technology growth, and obviously law keeps catching what Nipun was saying. I guess that is true, because even we technocrats, we keep on catching with the technology, and we keep on changing it for the betterment of consuming the services, betterment of serving, be it on the financial front, non-financial, education, and every sector we are trying to kind of technologize, digitize, so that it becomes easy to consume, right? So yeah, I mean, that would be my thought on this.
Right, so I agree. So I think now we'll quickly move to the audience questions, because I was ideally supposed to stick to script and ask one question per person, and then I got carried away because of all the things you all were saying, and I asked you all multiple questions. So we'll quickly move to the audience questions so that we don't run out of time. So the first question is, how do you think we will be able to find the balance between ensuring our data is safe and yet be able to share information online? Anyone can answer that, whoever.
So I guess I said it's up to us what kind of data we are sharing. Why are we sharing? As simple as let's talk about our resumes and CVs. I mean, when we are, at least when I am hiring a technocrat for his profile, I'm looking at his skill sets in, say, cybersecurity or cyber defense. I'm not bothered whether he is married, is single, whether his hobbies is singing, dancing. But we tend to share so much information about ourselves. Even my own CV has a lot of my awards which I've won in my college days when I used to play football. But why is it there still? I mean, that is where we have to be very cautious what data you are sharing. I mean, this is what I typically tell, that if it is really not required, when you're thinking that I will not stand in a park with a microphone and say about these things about me, then you don't share these things online on any of the platforms. It's not about they will, we try to park it that, yeah, it is safe there, but it is not, it's not at all safe anywhere. Till the time it is, the moment it leaves you on any digital platform, it is open to public. So you should be accountable, start building accountability by yourself. Yeah.
Right. So we should be careful of what we're sharing, and automatically probably a lot of our data will be protected because it's not shared. All right. Would someone like to add to that, or should I move on to the next one?
Well, I think there's another aspect to what Shashank was just saying, which is um, I completely understand that there has to be what you call a responsible citizenry, digital citizenry, right? That they are digitally literate to tackle the kind of challenges that are being thrown by tech, or let me put it, unscrupulous users of tech, right, at them. But the Supreme Court was also faced with such a dilemma In fact, it was argued by the central government in the Puttaswamy hearings that privacy is a very elitist concept. Tomorrow, a farmer just needs their 5 kg, so they have no problem giving their biometric information. It is you elite, city dwellers who have studied a lot and who feel that their personal information is being compromised. Supreme Court rejected that argument straight away and said, privacy, whether the citizenry is yet ready or not, is a different question. But that by itself cannot take away the right of privacy of an individual. It applies with equal force to a farmer who is standing outside a PDS shop, and it acquires with equal effect to you and I who have had some semblance of education, uh, might I say. Right? So
Yeah.
that.
I really think though you should think about the t-shirt thing. Okay, so the next question is what has been excluded in the latest draft of the data protection bill?
Well, for, for starters, the very definition of sensitive personal data has been taken away. You have a data protection bill and you don't define sensitive personal data. That's the first loophole. It's like saying let's bell the cat, but where's the cat?
Nipun will get lots of cases. Very good business.
I think from starters, it's a no go for me, and because I distinctly remember I have worked on these issues with Prachi's elder sister also, and these issues are very how do I put it, very close to us. So when we see this sort of an exercise, which in all fairness is a dishonest attempt to bring out a legislation which does not even do or achieve the bare minimum, the basic common minimum guarantees that right to privacy envisages. If somebody were to put a mirror to the opinion of justice calls and then see whether this bill does justice to any of the 9 forms of privacy. In fact, it's a scholarly opinion written by Justice Call in the 9 judge bench. He says there are 9 different facets of privacy. There's spatial privacy, there's digital privacy, there's privacy of the home and beyond, there's a bodily privacy also. And then he elucidates by giving different examples from different cases, from Miss X versus hospital to so on and so forth. I mean, he traces 65 years of privacy history right from Khadak Singh till Puttaswamy. And if somebody were to read that judgment to get a sense of what it is that you want to put today for the people of this country. So I think if somebody were to measure it with that, with those opinions in mind, then they would see what a dishonest attempt it has been. For the lucky few of us who have had the pleasure of going through the judgment, we see that it's a very sorry state of affairs. So so that perhaps answers the question that what has been excluded. I think
What has been
almost everything which is important has been excluded.
Right. Would you like to add to that, Prachi?
Yeah, Nipun is saying it absolutely correctly. Almost everything is except they would, once it got changed, we were hoping they would borrow a lot from GDPR as data portability. They did not. It's like almost everything that we included, because want a new version of a bill to be more inclusive and more aggressive about action, but of course none of that is there, and eventually we will be seeing more interpretation being a law. But yes, absolutely, I totally agree with Nipun. A very agreeable bill at this stage, but let's see, maybe there might be changes or might be amendments later in future for a hopeful future.
Yeah. So the next question is, what are the consequences of not complying with the personal data and protection laws?
Prachi, I think you should take this one.
Just that so far the 10,000 penalty of hitting the consent button. So there is not much of non-compliance that's going to happen. It is a very comprehensive list of our see in this bill, our and duties overtake our right to data privacy. We have more duties as per this new proposed bill. So the penalty is of course 10,000. Everything else we are giving our consent to. It is as I said, it's not very transparent. It is you have to comply. There's no going about it. But if you are going beyond it, for now, for the data principle and for firms and all that I already discussed, goes down to bills.
Absolutely. Okay. Would anyone else like to add to what the consequences could be?
Well, just to borrow another phrase, the adverse consequences are like a toothless tiger.
Okay. Okay. I think that's explanation enough of what our question was. Okay. So if anyone doesn't have anything to add, with this we could then come to the end of our discussion today. It has been an absolute pleasure talking to all of you and learning from all of you. I would like to a little bit try to put in perspective the importance of this bill. There are currently over 760 million people on the internet in India, and it is projected to touch 1 billion people. We hope that in the coming year we will have a concrete law protecting our personal data online. Because like we've discussed in today's session, this data that we have online is extremely important and needs to be protected. So on behalf of the entire team of Rest the Case, I would like to thank all the panelists for taking out their time from their busy schedules to be here. It was an immensely insightful session and has given us a fresh perspective and actually a perspective to begin with, because there are so many things that we have learned today that for me at least I had no idea about. And thank you so much to our audience. This event would not have been the same without you all. We would love for you to have a look at our website. The link is in the comment section. We hope to see you all be a part of all the future Rest the Case events. Once again, thank you all for being here. Stay safe and healthy and have a great day ahead. Thank you so much.
Thank you. Thank you all.
Thank you.
Thank you, Shreya.
Thank
Thank
you.
you,
Very
Shreya.
nice having you.
Thank you, Prachi.